All right, let's bring in our guests to discuss what we're hearing. Joining us this hour is former head prosecutor and defense attorney Bob Bianchi. Bob, great to see you. Thank you so much, as always, for joining me here on the program. I want to get your thoughts on what we're seeing. In my mind, earlier today, I said that finally the state's putting a little bit meat on their claims about conspiracy and all that. I'm starting to see where they're coming from. I think this particular witness is a great witness. His demeanor, his delivery, very credible. Your thoughts thus far in the state's case?
Yeah, this is a great witness. It's a necessary witness for the government. They got to put this on without any question. It's funny when you were just asking that, Michael, I'm getting ready to prepare for a trial myself. And the big question that's coming up with my team is to what level, if any, do you stipulate to some of this testimony? It's virtually uncross-examinable. And from a defense perspective, the issue is going to be, what towers are hitting in the cell phones. Let's just really get to the heart and meat of what we need here from the defense perspective, that the prosecution has to do it. So I'm kind of curious in a rhetorical way. A lot of defense lawyers are of the opinion, like, you make the state prove every single thing and you don't stipulate, but then you put this kind of witness on, which kind of boosts the credibility of the state's case. It's an easy cadence. He's a good witness. It's kind of binary in terms of what his testimony is, and shows a little polish on behalf of the prosecutors. So again, the real issue is going to be, how's she going to cross-examine this witness? Because as I said the last time we were on, last point, Michael, is that every time she gets up and she speaks, she may not be on the witness stand, but she's communicating to that jury. And they're looking at her demeanor, her aggressiveness, her control, her mental acuity. All these things are going to be important in how they're going to relate to how she was on the day of the incident, whether that's fair or not.
Yeah, no question about it. But I got to say this, Bob. One thing I don't know if this is by accident or something that she's planning on doing. One of the things that I think she's doing extremely well at goes to your point. Even in her questions, I don't know if she knows there's going to be an objection, but she's testifying in her questions. Now, they're getting objected to. The objections are being sustained, but she's saying what she wants to say about certain things, and it's getting in front of this jury. So as far as that's concerned, again, I don't know if this is how she's planned it or worked with her attorney on how to do this, the person who's second seating her and giving her advice in this case. But I think that aspect, as far as representing herself, she's been doing very well.
Michael, 1,000%, and I know we may be in the minority a little bit here, but she is doing an extremely credible job. Now, she's missing some things here and there, but I think that that's going to get lost on the jury because she's not a polished professional attorney. She's presenting herself well, and so I wrote these two things down here. I said this the last time we were on the air. Is this going to be a situation where a small pebble overturns a large carriage? That she's going to go against the state and literally win a case? I've seen it happen. Or will she prove the adage, he who represents himself has a fool for a client? I guess we'll see.
Yeah, I think there's a little space in the middle there. I think she'll get convicted.